case briefs, and so much more. LSData's got what you're looking for.
The New York City Civil Court addressed a complex dispute involving tenant alterations to a property without landlord consent in the case of Marbar Inc. v. Katz in 2000. This case underscores the need for tenants to get written permission from landlords before making substantial structural changes to a property. The tenant in question, under a rent-stabilized agreement, replaced an older, slightly uneven deck with a new one and installed a complete new patio without seeking the landlord's permission. Her primary motivation for these upgrades was the safety of her child. While the tenant asserted that she attempted to contact the landlord before embarking on these changes with no response, the landlord presented evidence showing no permission was granted for these alterations. Interestingly, the tenant had not received any objections from the landlord or its predecessor concerning a violation of the lease before 1999, and the landlord could not provide evidence to show that the alterations posed any hazards. Yet, the court noted that significant property alterations were made, impacting the landlord's property rights. The court contemplated whether these infractions were serious enough to justify eviction, or if a remedy could be offered to balance the landlord's property interests and the tenant's right to secure occupancy. The verdict favored the tenant in this regard. The court determined that the tenant was required to remove the patio and possibly the newly constructed deck, and if the old deck had been demolished, a $5,000 bond should be posted by the tenant. The bond would cover the cost of restoring the property to its prior condition upon vacating, and would be forfeited if the tenant failed to restore the deck. This ruling emphasizes the crucial legal requirements for tenants to seek permission in written form from landlords before initiating significant property alterations and the potential consequences of overlooking these mandates. The case of Marbar Inc. v. Katz underlines this key area of tenant-landlord agreements, while carving a path for potential remedies in cases of unauthorized property alterations.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.